Hi, I'm Candace with Slusher Home Care Consulting, and today we're going to talk about employee tax status in home care. A lot of people are under the misconception that they can just do a 1099 and not have to pay employee taxes, but there's a lot more complications than that. In researching IRS, I'm going to be quoting a lot of their definitions for contractors and then pointing out the discrepancies as to why your staff actually need to be W-2. It's pretty important. And if you are already doing 1099s, you're going to want to evaluate whether or not this is the right thing for you. Okay. So the IRS's definition for a 1099 contractor means that it's an individual who works for themselves and pays their own self-employment taxes. And that's usually the big, hey, everybody, we don't have to pay employment taxes as long as we have 1099s. And that is true, except that 1099 definitions don't necessarily fit employee, like home care, caregiver, employee definitions and the things that you have to do forward with your staff. So agencies would save money on payroll taxes, sure, till you get caught, right? And everybody gets caught by the IRS eventually. So you're just going to need to be very diligent about that. Now, if you're in a state that's unregulated, you may be able to get away with it, but I would talk with your CPA, your accountant, your bookkeeper, and make sure that the way you practice your business really does fit the IRS standards. So the other thing is these base level workers often just don't pay their taxes. If they don't come out of their check, they don't pay them, and then they get caught by the IRS, and that's not going to be sustainable for you either, because they're going to say, I'm actually going to have to go work for an agency that does W-2. You won't be able to keep them forever because that'll catch up pretty easily. Now, the main thing that caught my eye in looking at IRS's rules, it says, the payer only has the right, the payer is you, the agency, only has the right to control the result of the work, not what will be done or how it will be done. Now, as an agency owner myself, that thought kind of terrifies me. You mean I just wouldn't have any say so in what my caregivers do or how they do it? That right there should be the first red flag that 1099 is not for you as a home care agency. So what this means is that you as the agency have no legal right to control the details of how services are performed or the hours scheduled or worked. Under the IRS common law rules, anyone who performs services for you is an employee, and the term employee means W-2. Okay, if you can control what will be done and how. It is the substance of the relationship, not the label. Doesn't matter what you call them. It's the substance of the employee-employer relationship that governs the worker's status. Okay, so let's dig in a little bit in home care, why it contradicts 1099s. Okay, especially in regulated states, the state will require you to do these things for or with your employees. So the agency must have control or a definite say in orientation. This is how we do things at the agency. That's not something you do for a contractor. Training to make sure that they have the skills needed. That's not something that would be done for a contractor. Clocking in and out, times and schedules, when they go to work. Not something you could do for a contractor. They make their own schedule. The care plan or service plan for your clients that you set up with your clients, what's going to be done. You technically with a 1099 couldn't even share that with them because they have control over what is done and how it's done, as opposed to you having say over what the employee is going to do when they're with your client in the care plan or service plan that you set up with your client. So again, that just doesn't fit. Evaluations of performance, not something you do with a contractor. Supervision of work. You have to go out and supervise what they're doing. Not something that's done with a contractor. And then, of course, disciplinary action when it comes up. Now, all of these things dictate that your staff must be W-2 employees. I have had conversations with at least half a dozen lawyers, and I know we're in Texas and we have big rules, but even outside of Texas, if there's any sort of regulation, it's for sure going to be that you have to have W-2 employees or they're not acting on your behalf, right? A contractor represents themselves, not you. They're not employees. You don't have say-so. You don't give them a name tag. It's just different. So I just wanted to ask everybody, evaluate. If you're not doing W-2, Are you crossing that line? You probably are, not even walking it. You're probably way over the line based on what the IRS definition is for contractors. And if that's the case, you can switch over and make everybody W-2 employee right now. I recommend that before somebody gets caught, before some kind of red flag goes off. Okay? Good luck to you. Reach out if you have any questions at slusherconsulting.com.